हाय गाइस, आज हम बात कर रहे हैं हिंदू सक्सेशन एक्ट ऑफ 1956. As per the Hindu Succession Act of 1956, it deals with the property rights and inheritance. This act actually gives a broad view based on the Hindu Succession Act either to the property and the rights that have been available for both males and females in order to acquire of the property of the deceased male. As per the Section 2 of the Hindu Succession Act of 1956, it actually talks about the applicability of the Hindu Succession Act of 1956 to whom it will be applied. It will be applied either to the Hindu, Jain, Buddhist, Sikh by religion, and it won't apply to a Muslim, Christian, Parsi or ST. Now we shall see some of the important changes that has been brought by Hindu Succession Act of 1956. They are as follows. First of all, we shall start with the changes in the Hindu joint family. Okay, so it actually talks about the pre-existence. As per the old Hindu law, the co-parsoner who was not having any right in order to make a will with respect to the property in the family, but as per the section 30 of the Hindu Succession Act, it actually enabled the co-parsoner in order to write a will with respect to the property to its joint Hindu family. And secondly, after the death of the co-parsoner, the principle of survivorship was recognized. For example, if the death of the co-parsoner, then it won't be applicable to the widow or the daughter, but the survivorship of the co-parsoner or is nothing but the other person of a co-parsoner in that joint Hindu family, he will be having entitled for the inheritance of the property. But as per the section 6 of a Hindu Succession Act, several changes has been made. They are the co-parsoner, the death of the co-parsoner, the property will be going to the widow, daughter of the deceased person. Next, we shall discuss about second, that is the abolition of Sapinda's relationship and what are the changes that has been brought of the Sapinda's relationship under the Hindu Succession Act of 1956. So first of all, Sapindas in the sense the earlier they used to marry between the brother and the sister in the same family, but as per the new law it was being abolished under the Hindu Succession Act of 1956 and it has made equal proportion of the share of a property between the male and the female. So third one, we shall discuss about the removal of disqualification. Removal of the disqualification in the sense now these disqualifications have been abolished. They are lunatics and idiots or unchaste widows. These has been abolished from the disqualification. The fourth one, that the separate property of the male, it is a thing, but the succession of the widow, the succession of that deceased male, the property will be divided namely to the son, daughter, widow and mother. Can these or all people can inherit the properties of the deceased with the equal proportion. Okay, so next of all we can actually discuss, that is a fifth, that is the changes in illegitimate sons. Changes in illegitimate sons is nothing but the right of succession of illegitimate son varied from school to school. Okay, it also depend upon the caste the which that children belong or to which the parents belong. But now illegitimate son is recognized only with the reference to the mother but not to the connected father's property. Okay, so last but not the least, cognizant and uterine blood relation. Cognizant is nothing but husband having more wives. Okay, with respect to the children among themselves is called as an consanguinity. Uterine blood relationship is nothing but a wife having more than one husband and the relationship of children among themselves. Okay, so under the old Hindu law, the consanguinity was recognized and the Hindu female could not have two husbands in her lifetime, but in the present Hindu law, uterine blood relations are also recognized. Thank you.